Good afternoon and good morning, everybody. Welcome to Taylor Wessing's Immigration Seminar, Brexit and Beyond, UK Immigration in 2016. I'm Sean Nesbitt, and I'm joined by our experts from the Employment, Pensions and Mobility practice in Taylor Wessing, Vicky Weiberg and Charlie Pring.
Hello.
Hi.
You can see their details on the screen in front of you, and if anybody has any technical problems, please use one of the coloured tabs, notably the yellow question box, to get in touch if there are any issues. If you'd like any general Brexit material after this talk, please look at the resource list on your screen, and you can see video highlights from our sector specialists. Our website also has links to our Law at Work publication, which has monthly client news on all aspects of employment, pensions and mobility. Now, as with any webinar, we're keen to gather your questions, so with over 100 of you out there, please don't be shy. Send any specific questions as soon as you like to us using the Q&A box, and you can see it at the bottom right of your screen. Now, I'm looking at the overview slide in front of you, or it should be in front of you. Our title comes from the Toy Story catchphrase, "To infinity and beyond," which the youngest of you will recognize from Buzz Lightyear. Now, as we all know, you can't go beyond infinity, but it looks like in the UK, after the vote on Brexit, we're going to have to. But it's not just a concern for the UK and the EU. The recent G20 meeting of leading countries last week had representations from President Obama and also from the Japanese Prime Minister expressing concern about the risk of flight of business and the ease of doing business with other countries away from the UK unless the UK can work it out with the EU to more or less replicate the current systems that we have, including for free movement of people into and out of the UK. That's not just a concern for countries, of course. More than anything, this is a pressing concern. It's the hottest topic for employees within businesses. In the UK alone, we have over 3 million people who are EU citizens, never mind citizens of the United States, Japan, China and elsewhere. And if every one of those EU people decided they wanted to establish the right to live here permanently, at current rates of processing with the resources we currently have, it would take 140 years for those people to get their applications processed. Does 140 into 12 go? Even I know that isn't so. So, there's a lot of people who need assurance, and Charlie and Vicky are here to give you some tips on how to help provide that if you want to as an employer. But business also needs to balance customer and regulator attitudes too. The recent sting on illegally employed workers at Byron restaurants provoked an awful lot of comment in our press, both from press supporting the government clampdown on inward migration, but also from customers, and especially younger customers, who were unhappy at the way workers had been treated, and saying that in effect business had over-complied and they wanted to boycott Byron. And it's reported that their profits are materially down since the news of the sting was published. So in this seminar, we hope to give some key messages and some tips to help you manage those twin tracks of your people and your customers and regulators, and help business keep on track with what it needs to do normally while we try to find a way forward on Brexit. Now over to Vicky.
So I'd like to start by looking at a hopefully useful pie chart which sets out the migration, net migration into the UK by the end of March 2016. As you can see, EU migration is about 44% of our migration through to that period of time, non-EU migration being about 46%, and returning Brits about 10%. And actually, that's decreased a little bit since the previous year, but only by, I think, about 9,000 people. So quite interesting to see how that will compare potentially with next year and whether EU migration will increase within that percentage. I'm sure everybody on the webinar today is aware that the Brexit referendum was on the 23rd of June and the decision was made to vote to leave the EU. And I'm sure most of you also know that whilst we're now going to be working through that process for the next 2-year period or so following the invoking of Article 50, currently there is no immediate change to EU nationals living in the UK, or in fact UK nationals living in Europe. Those nationals have the right to automatically work, study, be self-sufficient, etc. in the country they picked without first applying for a visa, and that's not going to change until we know what the process to extract the UK from Europe looks like. We assume that there will be some form of transitional arrangements which are introduced at some point, which will ensure that EU workers who are currently in the UK are able to confirm their UK immigration status, and this is a topic which has been very high profile in the press recently. We're not too sure exactly what that will look like. Equally, we're not too sure about the exact mechanics of the process of Brexit and when the cut-off date for entitlement to evidence workers' rights in the UK will be, and those are all things that are going to have to be considered and decided by the government moving forward. So given that we don't know what's necessarily going to be happening in the near future, what does the referendum really mean at the moment? Maybe we can look at some statistics. There are currently about 2.2 million EU workers in the UK, and that's about 6.6% of our total workforce. And we've looked at sort of the percentage of workers in the UK against non-EU nationals. It's kind of interesting to note that 75% of those EU nationals currently working in the UK wouldn't actually meet the current points-based system visa requirements which apply to non-EU nationals. And Charlie's going to be talking about the PBS requirements, particularly around Tier 2, which is the working visa route, in a few minutes. So that's going to be interesting to see how the government manages EU national rights moving forward, given that many of the roles that the EU nationals currently fill in the UK tend to be maybe lower skilled. That drops down to 66% in banking and finance, but increases to 94% in hospitality. So this is going to be a real issue for those of you who work in the hospitality trade in the future. And actually it increases again to 81% with the new higher earnings threshold, which will be introduced under Tier 2 in April 2017, which Charlie will talk about a bit later. It's also, I think, important to flag, as Sean mentioned, that a lot of workers, EU workers in the UK, don't hold any form of visa. So only just over 27,000 permanent resident cards were granted in 2015, and as Sean mentioned, that leaves a real uphill struggle to process applications if most EU nationals here decide to apply for a visa. So mentioning, as I did, that currently there's no change to the status of EU nationals based in the UK, what might EU nationals here wish to do to protect themselves in light of the fact that we're very uncertain as to what's going to happen in the next year or two? So no visas are needed yet, but it may give reassurance for those who are eligible to apply for a visa. If EU nationals have been in the UK for 5 or more years and they've been exercising treaty rights, which often means working but may mean studying or being self-sufficient, they are eligible to apply for permanent residence. And that is a right that is granted automatically, but in order to evidence your right, the EU national would need to make an application to the Home Office to obtain a permanent residence card, which they can then present as evidence that they have crystallised their right. It takes the holder outside of immigration control, so it means that holders of PR will not be affected by any changes to the rules in the future. And EEA national family members can also apply alongside the main applicant or on their own, depending on their backgrounds. And non-EEA nationals could do so as well, but would need to consider a bit more carefully about the application of the rules to themselves. The applications are currently postal. It's a £65 fee per person, but the flip side of that, because the fee is low, the processing time is very slow. It's about 6 months at the moment. We do know that there is an online system being trialled at present, and we anticipate that should speed processing times up, but it's a case of watch this space. An application for PR is a destination in its own right, so you don't have to make any other application in the future. However, if you wish to, you could also apply for British citizenship, having held PR for 1 year, and we're seeing an increase in clients who are looking to do that. For those of you who may have staff or may yourself not have spent 5 years in the UK, you can apply for a registration certificate, which is again an evidence that you are exercising treaty rights in the UK. Again, it's a postal application, although you can make these in person as well, and the fee generally around £65. Probably we see less people making those applications at the moment, but that may change when we have more clarity on the Brexit negotiations. So we've looked at what EU nationals could do. What about employers? As Sean said, we need to think about both sides here. We would say that if you have EU national employees who are wanting, who have spent more than 5 years in the UK, you may well wish to support them in applying for permanent residence. And that could come in many ways. You might, for example, wish to pay the fees for them. You might want to give them access to legal support, for example, through ourselves. Or you might want to give them some template information that they could use. There's various ways that you could support your staff. I would say that it's worth encouraging staff members to apply for PR sooner rather than later, because as we know, there may be a real increase of applications down the line. We wouldn't recommend that you change your recruitment model. We have some clients who say to us, well, maybe I should stop hiring EU nationals now because I'm not sure what's going to happen in the future. And I would recommend that you don't do that, because you may find yourself on the receiving end of a costly discrimination claim and also adverse publicity. You might want to think about fixed-term contracts or break clauses in your contracts so that you can reassess costings, for example, in the future when there's more clarity on the Brexit negotiations. And you might want to pass on increase in cost or red tape requirements when applying for visas to customers. For example, if you're providing staff members to a customer and you know you might need to get visas for them in the future, maybe thinking about sharing their costings there. You might want to think about examining your existing outsourced arrangements so that you can make sure that your key workers in particular are still going to be available to work for you in the future after Brexit. And as part of that, I would recommend considering your hiring needs now so that you can make sure that you're going to have the spread of skills, particularly maybe language requirements moving forward. And that's particularly going to be the case in areas where there's a higher proportion of EU nationals working. And finally, you would want to look at your future training needs. You have a 2-year window, at least, we hope, to assess your training and your staff requirements. So being able to take steps now to protect yourself will be something that you can proactively do. So that's enough about Brexit. I think I'd like to now look at the Immigration Act with you, which was rolled out from an immigration perspective on the 12th of July of this year. And this has got a couple of quite important implications that I'm sure most of you are very familiar with already. The first one is that there is a change in the criminal liability for those who are employing people illegally. So historically, to be found guilty of a criminal offence, you had to knowingly be employing somebody illegally. Moving forward from the 12th of July, the threshold has been reduced quite significantly, so that if you had reasonable cause to believe that somebody did not have the right to work in the UK legally, you would be guilty of that illegal working offence. Coupled with that is an increase from the potential prison sentence that you might receive from 2 to 5 years. I think it's worth saying at this point that we're not aware of anybody who's been sentenced to prison for 2 years. So it's not that this is a power that's been used by the Home Office regularly. However, with the decrease in threshold, it's possible that the Home Office will start to look to bring more cases in the future. Also, employees who are themselves convicted of working illegally can, from the 12th of July, be personally liable for a fine, which is up to 51 weeks of pay and or 6 months imprisonment. And though the pay that's been received by those workers could be recovered under the Proceeds of Crime Act. So the Home Office for the first time is also looking to prosecute employees and not just employers who are found guilty of working illegally. Now, the other point there, actually, it's a future point which will take place from next month, we understand, is the power to close premises. if there's been a pattern of illegal working. As we've noted, this is going to be a particular concern to high-risk industries such as hospitality or retail or construction, but it will remain to be seen how that would operate in practice. There are other implications of illegal working which have already been in place before the 12th of July, but I think is worth mentioning, particularly in light of the Byron Berger raid that Sean mentioned in his introduction. So I'm sure you're all familiar with the idea that there is a penalty of £15,000 if you are found to have been illegally employing somebody, and that can rise to £20,000 if you have a previous breach in the last 3 years. There would be a reduction in the fine if you are found to be cooperating with the Home Office, for example, or if you've carried out some checks or provided evidence to the Home Office when they've requested. There is also the ability of the Home Office to publish details of employers who are subject to civil penalties, which I think is a publicity matter that you're not going to want to be having to deal with. There is a question about who is liable in this case, and generally it would be the employer who is liable for the penalty, but the Home Office, in our opinion, is not always as clued up about corporate structures as many of you will be, so it's not uncommon for a civil penalty to be issued to the wrong party. As you've mentioned, the Home Office has really increased their right to work checks recently, and that can be seen particularly through the Byron Berger raid, which I think was last month now. The Home Office worked with Byron Bergers to deport 35 of the Byron Berger staff, and the Byron Bergers cooperated with the Home Office by arranging a training session for those staff who were all in the UK illegally, and the Home Office then arrived at the premises and took the workers away. I think it's important to note that Byron Berger had got right to work evidence for all their workers who were in that meeting, so they were not actually liable or potentially liable for a fine, but there was a real fallout, a very quick fallout actually on social media in relation to the actions that customers of Byron Berger and the general public saw that they'd undertaken and the way they'd managed that raid and the arrangements for it, and it's had a really long-lasting impact on the company's reputation. So I think it is important, particularly if you are in a high-risk industry, that you think about how you might manage a raid, and maybe have, if you have a press team or PR team, that you have them on hand with a statement that you would issue, or that they would be available to help you if that event took place. I think with Byron Berger, the news spread over the internet incredibly quickly, so it's important that you're pre-thinking about what might happen. And you probably also want to think about the impact on the duty of trust and confidence for your staff. If you make arrangements to work with the Home Office to facilitate them being deported as part of a raid, are you breaching the duty of trust and confidence you owe to your staff? It may be worth just spending a few minutes just looking at the right to work rules, which will be relevant in that kind of Byron Berger situation. And under Section 15 of the Immigration, Asylum and Nationality Act, employers are liable for employing anybody without the right to work in the UK, and that can give rise to those civil penalties and criminal penalties that we've been looking at. However, there is a statutory excuse if you take compliant right to work documents, which are set out in the list issued by the Home Office, and those have to be taken before the individual starts work. It's important that when you are undertaking right to work checks that you do look very carefully at the original document that the employee produces, and that you take clear copies, having checked that the document is genuine, that the photo, for example, resembles the person in front of you. You've checked that the dates are compliant, that the right to work still is in existence. And it's important that you keep a record of those documents that you have taken and put them on your files. You will need to make a note of the date that the person's visa expires, for example, so that you can go back to them and take fresh right to work document evidence in connection with maintaining your statutory excuse against a charge. And it's important that you contact your staff in advance. So, for example, 2 or 3 months before their visa expires, you're working with them in order to make sure that you have the right to work evidence and an ongoing statutory excuse. So you might not be familiar with the right to work evidence that you would need to collate. Well, there's a right to work checklist that the Home Office has produced. It's a very useful, I think, 2-page document, and it's very clear and easy to use. And we'd recommend that you do put that on your files for all of your staff. You might, for example, need to look at that checklist in order to check the documentation that has been provided to you. So, for example, just looking at our tables of examples of right to work evidence, if somebody produces a birth certificate for you, if they're a British national, that's acceptable as an evidence of right to work. But you would, as well as that birth certificate, also need a long form an official document noting the individual's national insurance number, which was issued by a government agency or a previous employer. And normally we'd say that would be, for example, a P60 or a P45 or a national insurance card, and all employees should have access to those documents. You need to, for example, check that the name in the documentation matches, and if it doesn't, you might need to ask questions. You may need to get a deed poll showing the change of name, for example, or a marriage certificate if somebody's name changes due to marriage. You need to make sure that a visa in particular is in a current passport, and that change was introduced in May 2014. So if a visa holder comes to you to start work and they present an expired passport containing their visa, you'll have to ask them to transfer that visa into their new passport before you can allow them to start work with you. And finally, and very importantly, you must see the original right to work documentation from anybody looking to start work with you. If they email the copy to you, for example, that's not going to give you the statutory excuse against the right to work penalties. So hopefully that's given you some information. The Home Office has a lot of very useful guides of varying lengths that you can refer to, and obviously we're always happy to help have a look at specific documents with you. I'm now going to pass on to Charlie, who is going to look at Tier 2 sponsored visas and some of the changes that we are seeing that are going to be coming into force in the next month or two.
Hello everybody. So I wanted to talk specifically about Tier 2 visas, sponsor licenses. Many of you will have an immigration sponsor license, which is the framework permission that enables your UK business to sponsor Tier 2 work visas, the main work permit route we have in the UK. Some of you may not have a license, but it's worth thinking about whether or not you should get one in the future. We're seeing it now as an essential recruitment tool for businesses so that they can hire the talent they need. So we're going to look at the latest changes to the visa eligibility rules, and then also increasingly important compliance update as well around maintaining your license, complying with the various duties that are imposed on UK sponsors. So over the last couple of years, there's been a lot of discussion about immigration. It's been high profile, constantly front page news around how the government will impose restrictions on immigration, how it will control net migration numbers that Vicky mentioned earlier because they're at record levels. So I thought it would be useful just to look at some proposed changes that have been floated that are not coming into law. I know it's confusing because the Migration Advisory Committee, which is the body that advises the UK government on immigration policy, has suggested various things. But I wanted to look at things that have, or ideas that have been suggested, but that are not coming in, first of all. Now, the first is to remove the automatic right of spouses and partners of Tier 2 employees to work in the UK. So it's always been the case that the spouse or non-European spouse or partner of a Tier 2 visa holder can work for any business apart from as a doctor or dentist in training or as a professional sports person without restrictions. Completely optional, but they have that flexibility, and in actual fact the spouse or partner is in a better position in some ways than the Tier 2 visa holder whose permission is tied to their employment with the sponsor. The spouse or partner can work for any business. Now that there was a suggestion that maybe that automatic right should be removed to take away one of the pull factors to encourage that encourages people to come to the UK. But the good news is there's going to be no change to that rule, so spouses and partners can continue to work without restriction. The other area where there was particular concern with the government was around Tier 2 intra-company transfer employees that work at a third-party site, a client site, for example, rather than at the sponsor's address, and the concern that companies were hiring from overseas and undercutting the salaries of local employees. So there was an idea that perhaps there would be a complete prohibition on intra-company transfers working for third parties. But actually the outcome on that is that they will continue to be able to work for third parties. It's always important, it has been and will continue to be, that there's evidence of the time-bound services or commercial contract between the sponsoring organisation and the client organisation. But the way that the government are going to deal with it is through an increase in salary for intra-company transfers, and we'll come on to that in a minute. The other suggestion was that perhaps intra-company transfers should have a minimum 24-month service requirement overseas rather than the current 12, but again that's been rejected, so we're sticking at 12-month service overseas if you want to arrange an intercompany transfer. One suggestion was that certain roles which are very common, for example business development or sales executive roles, should be removed from Tier 2 visas to encourage more local workers to take up those positions, but again there's no plans as yet to change that. And finally, there was an idea that for all Tier 2 general recruitment, that's generally used for external hires into your business, that advertising, the resident labour market test, would be mandatory for all hires, and that also UK applications in that category, which are currently exempt from the UK's immigration cap, should be brought within the overall limit. Again, both of those ideas have been rejected, and so the current exemptions will continue to apply. Okay, so we've got a series of Tier 2 changes coming up this autumn, probably from the 6th of October 2016, although we're awaiting the detailed announcement on the change, and then another set on the 6th of April next year. So let's look at the autumn changes coming in from next month. The changes will cover both Tier 2 General and ICT. Starting with General, the main thing here is that salary levels are going to increase. So the minimum salary you have to pay to get the visa at the moment is $20,800, or the market rate for the role if that's higher, and that threshold will be increased to £25,000 a year as an annual salary from next month. There will be a couple of exemptions, the main one being if you're taking on a recent graduate from a UK university who's on a Tier 4 student visa, you'll still be able to pay the lower $20,800 rate for them for a 3-year visa, but you'll need to pay the much higher rate when you extend, because the government expects salary progression. There's a couple of other ideas that for Tier 2 General where we don't have the detail on how they're going to change, but there may be some extra weighting within the cap assessment for businesses sponsoring overseas graduates, and more flexibility around graduates to change roles. I think the main changes, both next month and in April, are going to be around intra-company transfers. At the moment, Tier 2 General applicants pay a contribution to the NHS of £200 per year of the visa, and their family members as well. Up to this point, intra-company transfers have been exempt. That exemption is disappearing from next month, so all Tier 2 applicants across both categories will pay the NHS contribution, which is an upfront mandatory charge whether or not the employee uses the NHS, or even if they've got private insurance. The skills transfer route, which is a 6-month visa to enable applicants to get skills or to impart skills to the UK, is going to be closed, partly because it has a much lower salary level and because of a fear, I think, that it's the companies are using it to get round the 12-month service requirement because it doesn't have the overseas service rule. And then finally, there's going to again be an annual salary increase for intra-company transfers. It will become a £30,000 limit for short-term transfers, so that's transfers up to 12 months. At the moment, it's just under £25,000 a year. That's going to rise to £30,000 from next month. And then jumping ahead, so I think I've skipped ahead one too many slides. Jumping ahead to April, again, salary changes are coming in. In Tier 2 General, the minimum salary across the board will be £30,000 a year, so it's jumping from 25 next month up to 30,000 from April next year, but with the continuing exemption for recent graduates. And in Tier 2 intra-company transfers, the salary across the board for all intra-company transfers will be 41,500. So regardless how long you want the assignment to be, even if it's only for a couple of months, it will be 41,500. So the short-term staff category is closing. So all intra-company transfers are treated the same way, except for graduate trainees. So that's assignments as part of an international graduate training program where the minimum salary will be £23,000 a year. The other main cost change that's coming in from April is a new immigration skills charge for sponsors. So that's effectively a skills tax which is being imposed on employers in both Tier 2 General and intercompany transfers. That will increase the costs of arranging visas. It will be £1,000 per year for large sponsors and £364 per year of the visa for small sponsors and charities. A large company is defined in the same way as it is for sponsor license applications. So you're deemed to be large if you have more than 50 employees in the UK and a UK revenue of more than £6.5 million sterling. Or alternatively, if any group company worldwide is a listed company, or if the UK company is regulated by the Financial Conduct Authority. Otherwise, the sponsor will be small, so most SMEs will be deemed to be small. There are a couple more exemptions on that fee, again for graduate level switches and for PhD roles. On intra-company transfers, finally, at the moment across the board you need a 12-month service if you want to come in from an overseas office. That 12-month requirement is being removed for high earners of more than 73,900 sterling per year. So if the proposed salary is above that level, that they could be a new hire into an overseas office and come straight away on an intra-company transfer with the big advantage that there'll be no advertising. And then finally, the high earner ICT level at the moment is 155,300 for those ICT visa holders that want to stay up to 9 years rather than the capped 5 years for everybody else. That threshold is dropping to £120,000 a year to enable ICT holders to stay 9 years. But the cooling off high earner threshold is going to stay at 155,300. So it's only for the ICT high earners that is going to drop. Okay, so to give you a flavour of the costs, the government costs for arranging a visa, there's a table here that gives you an idea of the breakdown of the various charges. You've got the certificate of sponsorship, the NHS surcharge, the government application fee, and then the immigration skills charge. So the first column relates for the period from October to April, and then columns 2 and 3 are from April onwards, but for small sponsors and large sponsors. So at the moment, it costs just under £1,200 for a single Tier 2 visa in either category. A family of 4, just over £4,000, because each family member pays the same rate. You'll see from April next year, for small sponsors, there's it's a material increase, but I think still manageable. But for large sponsors, there's a significant rise because it's a £2,000 per year of the visa. This example is for a 2-year visa, and if there is a family of 4, then it rises to government fees of £6,000 or £6,100. But there will be the same rate for both Tier 2 ICT and general, but of course you've then got to factor in legal spend and expat relocation package into that cost as well for an intracompany transfer. So what practical things can you do to take account of these proposed or these actual changes that are coming in? Well, you might want to consider accelerating any ICTs that you've got planned. I mean, we're only a month away, but it's still possible to get those through quickly if you've got a license in place to avoid the NHS surcharge. I think more materially in relation to the cost is to look at whether or not you've got hires coming up in the next few months and to accelerate those before April to try and avoid the skills tax, immigration tax, which is coming in next April. And I think we're seeing more interest from clients in trying to share the cost of visa approvals with employees. So more interest from an employment law point of view of putting in employment contractual provisions to claw back some of the fees in the employment contract, which typically would require a proportion of the fees, probably on a reducing scale, to be repaid should the employee leave the employer and join another company within a certain period after visa approval. And that's particularly relevant for Tier 2 general visas because most intracompany transfers are not allowed to change employer unless they're high earners. And then I think the impact of higher minimum salaries is to look at your workforce pay scales. Is it going to cause an issue to have higher base salaries for employees requiring Tier 2 visas than your local hires? Is that going to cause an issue? For those employees coming on international assignments, look at boosting the salary levels to get you to the required visa minimum using cost of living adjustments or other temporary pay scales which only apply during the UK assignment, which would then stop when the employee returns back to the home country. So let's have a quick look at the ongoing sort of compliance requirement. You've got your visa, which is great, but what do you then need to think about? And what we're seeing is that compliance is now just as important as getting the visa approval. So maintaining that visa by complying with the rules is essential. The Home Office or UK Visas and Immigration can audit your UK business at any time. They will usually be unannounced. They'll want to come in, they will review your HR procedures, your processes, the personnel files across the board, not just your Tier 2 employees, but also your local workers as well, and the right to work checks and employment agreements. They want to interview the authorising officer, which is the person responsible for the licence, and also one-on-one interviews with the Tier 2 employees as well to make sure that they are getting paid what they should and that their job is consistent with their visa.
So Charlie, just to cut across you, I've had a question in about some of the jargon or the acronyms that we're using as we speak here. Can you just clarify what does ICT stand for, which we've been using a couple of times?
Yeah, no, thank you. And so intracompany transfer. So that's the visas for employees of overseas businesses coming into the UK on an assignment. Okay, thank you. And so if there are issues, then the UK Visas and Immigration can downgrade the sponsor license and make you pay for an action plan to try and resolve the problems, or in the worst case, they can revoke the license, which automatically cancels any Tier 2 visas. There's generally no right of appeal to that decision, and there would then be a cooling off period of 12 months before the business can get another license. And for the employees, they may be in the same position as well because their visas will end and they may not be able to find another sponsor, which they would potentially face having to leave the UK. So keeping on top of the compliance duties is crucial. Have a look at Appendix D, which is on the Home Office website. That tells you everything you need to keep for a Tier 2 employee. Ensure that your key personnel involved with the licence are reviewing the Tier 2 sponsor guidance, and also you're having a think about the reporting duties, which we'll just summarise now. So from the business point of view, there are various trigger points which force you or require you to tell the government when things have changed. So if you move your UK trading address, if there are any key personnel on the licence, if they leave the business or are unavailable, for example, during extended leave, if there's a change of name or there's a rebrand, if there's any sort of TUPE transfer or share acquisition, even if that is taking place much higher up the chain of ownership, then that should be notified. Basically, any material change that affects the business, including insolvency or taking on a new registration with a regulator, all of these things need action, and generally speaking, within 10 working days of the trigger event. And then the same is true for changes to employee terms and conditions as well. If they change work location, for example, if they go to work at a client site or you move your UK office, if they have a material change in terms and conditions, particularly job title, duties, or a material pay change, but there's no need to notify about incremental pay rises, or if the employee, and this one is really important, if the employee leaves employment or the UK early before their visa expires, because that would typically lead to a visa curtailment unless they've extended their visa through another route or they found another sponsor. And so the government can only do that if you as the business tell them that the employee is no longer on your books. And all of these things can be done by the level 1 user and the personnel who are appointed on the licence. That will either be the lawyers or the UK company or both. So, Sean, do you want to wrap up and have a look to see if there's any more questions?
Yeah, I've got some more philosophical ones that have come in here. I'm just trying to think who I direct these to. I think so. Vicky, here's one. We've got one that says, as we tighten up now, who's going to be in the government sites? What kind of industries, or is there a particular finger of suspicion pointing at people from particular countries?
I think that's a really interesting question, actually, because I think at the moment the Home Office are really looking for some high-profile and easy wins. And we know that certain industries in particular are very much in their sight. So the industries that tend to have a higher turnover of staff, maybe more nationals from overseas, a higher number of European nationals and their dependents. So I think high-risk industries, particularly at the moment, are hospitality, retail, construction, care homes. And those are really the areas that the industries that I would be recommending are looking very closely at their compliance, their right to work documentation checks, not least in light of Byron Burgers, where the Home Office very much succeeded in obtaining a lot of publicity and probably a lot of focus on compliance.
Right, and so I'm guessing politically that matches those areas where workers tend to be lower paid, which is answering a political issue for the government, but as well as with high turnover areas where it's easier to catch employers out. Related question, what kind of tightening up, how does that take form? How does the state show that they're cracking down on people? What do employers experience when there's interest from enforcement?
I think what we would expect is more letters from the Home Office, who are working very closely with HMRC, so the tax authorities in particular, to keep track of workers who may not have the right to work. So we see companies receiving letters from the Home Office saying, we believe you may have somebody who doesn't have right to work, could you investigate that person? We may receive more civil penalties, so a penalty saying we think this person is illegal. You then have a period of time in which to either pay or to challenge the penalty, and actually there's quite a high success rate in challenging penalties. So if you do receive a civil penalty, do take legal advice, as they can be possible to challenge, or if not challenge fully, then to reduce the value of the penalty, and it's worth seeking advice from one of us as to what you can do rather than just paying automatically. I think that the things you can do to protect yourself really are just conducting a little audit of files, having a look back. It's very easy, particularly in industries with high turnover of staff, to find the right to work checks very onerous. So appointing somebody who has overcharged for checks, maybe an immigration champion or somebody like that who is really on top of the rules, can just be a reassurance to you, and also show the Home Office you're taking these matters really seriously.
And on the immediate sort of downside, risk management, are there any quick wins that you could suggest now, either of you, in terms of where are people getting fake ID? What would be an easy thing to spot at the moment in terms of catching the obvious areas of protecting yourself?
Yeah, absolutely. So I think what we're seeing is maybe an increasing number of fake ID cards from Europe, and those are relatively easy to get hold of, so I am led to believe. There are websites. There's a website called the Prado website, Prado website, which gives you guidance as to compliant identity cards and passports from different jurisdictions. So you can look at that website and it will take you through the way that the ID card, for example, should look, the type of typeset that will be on the card. I think often just being able to see the original document is important, because hopefully you'll see if it's been tampered with, or if a photo has been lifted. For example, if you're looking at an email copy, it's very difficult to see that. So looking at the original, maybe looking at that website. If you think that something looks a little suspicious, it's highly likely it is, so do take advice.
And what we've seen, thanks Vicky, what we've seen certainly from an audit point of view is an interest from the Home Office in ensuring there's an actual legal working policy or a system in place, so that there is things don't fall through the cracks, that there's a procedure that's followed consistently for all hires, regardless of nationality, under the code of practice. One of the points you mentioned, Vicky, I think is commonly an issue, which is employers relying on emailed or scanned copies of visas for the right to work check, rather than looking at the actual passport or biometric card in the presence of the employee, and that's something that can really help to make sure that it looks as realistic as one can hope for.
Okay, so Charlie, on the more structural thinking, I've got a question here. You mentioned that there are a number of changes that were on the rumour mill slide you talked about. Some of these are not becoming law. You've said yet. Does that mean they're going to happen next year after all, we're asked?
Well, there's no current plans, Sean. I think everything in that sense is up for review post Brexit, to see whether there'll be any alignment between rules for EU and non-EU sponsors and workers. But I think it will depend in part, and this is a policy point across the board, in what direction of travel we see in the net migration numbers. If the net migration numbers start to fall naturally through the next few quarters, then there'll be less incentive, I think, for some more really hard restrictions to be imposed, because that's really the driver behind a lot of the Brexit debate, and the policy is purely on the numbers. So we'll just have to see how that goes. But at the moment, we've had the outcome of that review, and there are no current plans to impose any of those changes.
Okay. Going forward, is there a sense of which industries or countries or even age groups are likely to be most affected by the changes you're describing as coming into place now, or as Brexit arrangements are made? Do either of you have a view on that?
Well, there was certainly a fear for Tier 2 sponsors that they would be priced out of the market, particularly startup companies and companies wanting to hire recent graduates, that the minimum salary levels would prevent them from getting the skilled people that they need. and fortunately there is going to still be an exemption on these salary increases for graduate hires. There isn't a specific exemption for SMEs and startup businesses, which I think is going to be an ongoing problem, particularly with the immigration skills tax. And I think that's going to be a group of businesses that will find it harder to swallow some of those higher costs.
And I think, I guess, from the more looking at the sort of Brexit position, the industries that are going to be affected are those that rely heavily on European national workers. So as we looked at, there's a really high proportion of EU national workers in, for example, the hospitality industry that wouldn't meet the Tier 2 visa rules if the points-based system were expanded to cover EU nationals. So from the Brexit perspective, it really does depend on what the government decides to do. And as we've seen in the press this week, Mrs May has decided that maybe the points-based system isn't going to be the fix for European nationals. So we're not really sure how that's going to pan out.
So a combination of those two answers, and I'll come back to another practical question in a second, but the combination of those answers makes me feel that if you're investing or posting workers from the United States, for example, or from China, or from Japan, whichever way it breaks out, it looks less likely that people will get the side effects of future changes than the people who have come from the EU states. Okay, so there's another question hit the screen here, and this is a very much a practical one that is one that I've had a lot of recently. Coming back to the right to work checks that you perform to check that a colleague or a prospective colleague can work with you, not just what do you look at and is it original or a copy, but when do you need to do that? I don't know, Vicky, do you want to answer that?
Sure. So the right to work checks need to be carried out before the person starts work. And that can be a practical point, as has been asked about, can you, for example, take right to work checks as part of the interview process, or could you ask the individual to come into the office on day one, talk to, for example, the HR team, and the HR team take copies? I think it really depends on the size of your business. My preference, I'm sure Charlie will give some thoughts as well, is where possible it's good to do right to work checks before somebody starts, so before day one, if that's how your interview process works out.
Yeah, because I guess the risk of doing it on day one, sort of at the very first moment of meeting them, is if the employee doesn't produce the right documents, you'll have to send them home until they can bring in the right evidence. So having it done up front means that you don't have that risk of delay. But the key thing about doing it before work starts is that you treat everybody the same. So if you're doing it at interview stage, anyone interviewed, for example, to final interview would produce them at that point to avoid any discrimination issue.
And it might be the case that if, for example, you run a multi-stage interview process, that you wouldn't want to ask individuals to bring right to work documentation in at the first interview stage, but maybe at the second interview, for example, because that way you'll cut down the number of checks that you need to do. And as Charlie said, you're then treating people based on their skills for the role rather than whether or not they have the right to work in the UK.
Okay. All right. So I'm going to sum up quickly now as we come towards the 5 o'clock stop time for our webinar. There is still time, because we've had a fair few questions come through while speaking. There's still time to smuggle one or two in if you want to. But while I'm looking at the screen, I'll look to conclude. Immigration is the single most searched topic in terms of government policy and the single highest preoccupation that our clients and contacts have had around the Brexit vote. So since June, it has been very firmly in the spotlight, and we know from practical steps that government and enforcement agencies are taking since the Brexit vote that while it takes a year or 2 years or maybe longer to work out the long-term strategic relationship between the UK and EU countries, in the short term the government is devoting resources to requiring employers to improve their procedures, to be more consistent, and to make sure they can show they're complying with the law. If the government cannot get a quick fix on Brexit and reducing inward migration, one area where it is within its control is to crack down on enforcement, and we see that they are going after what I guess they would call low-hanging fruit. As that expands out into the wider marketplace, we can expect more questions from consumers and colleagues about how they should feel and whether they've got a safe place in the country. So a key takeaway, I think, from Vicky's part of the presentation is there's a lot that can be done because unease is very prevalent and will be generated further through government enforcement actions in the coming months. There is a lot that can be done to reassure your colleagues that there's a holding position and that they're well-liked, trusted and well-regarded within the business now. At Taylor Wessing, for example, we conducted an audit post-Brexit and we found that we had nearly 20% of our colleagues were EU nationals working in the London office, and we hadn't had particular cause to collate that information before now. But we have learned a lot about how to handle concerns and how easy it is to deal with those concerns and make people feel better at the expense of very little money to support them through permanent residency or through demonstrating that they have the right to live and work here in case there is big change in the future. But the flip side of that is being careful and measured in managing your compliance and not unnecessarily spooking people or having them feel they've been singled out by your right to work checks. And I hope Charlie and Vicky have given some useful guidance on that. A key point to remember is that whatever the consumer market might be in the UK or regions of the UK, it would be wrong and unlawful to turn away people who are applying for jobs from EU citizenship at the moment. They would have a discrimination case. So need to be careful about being coherent and consistent in checking right to work for everybody and not trying to second guess government policy, because it seems likely from what we're seeing at the moment that the government will try and reel in the shape of reforms around Brexit and concentrate on enforcement and on the criteria to come and stay in the UK, which this government has said it still wants to happen. In closing, I think I will ask each of Charlie and Vicky in their own words to give us one thing to take away beyond that from each of you. So, Vicky, is there anything else that you would like to reinforce?
I think from what I'm seeing, the message really is to ensure that you are auditing your employee files, that you are making sure that you have compliant right to work documentation on file, and that you are doing that prior to being approached by the Home Office with any concerns they may have. If you're finding anything, investigate and take advice as to making sure that you do have a statutory excuse, because the penalties are high, and the Home Office is, as Sean said, looking to control what it can at the moment, which is looking to control legal working in the UK.
And Charlie?
So for those companies that don't have a sponsor license at the moment, do consider whether it's worth your while investing in one, because we do see clients that haven't got one yet miss out on the best talent. And for those of you that are managing a license now, have a think about whether there's any need to accelerate hires before particularly before next April, when the costs become higher, and have a think about how you'll manage those costs going forwards and the higher salaries. And as Vicky says, keep an eye on the compliance. Okay.
Thank you so much. So we're going to wrap up now. Please don't forget the contact details are both on the screen and can be got from our website if you have any specific individual questions. We hope this has given you some easy takeaways and reference points for future concerns. And in return, we would ask, please, if you do have a couple of minutes just to complete the feedback questionnaire on the webinar in terms of how it's gone, but also any points of topicality or future interest that you think would be relevant and you'd like to hear about, we would very much welcome them. Thank you so much for listening, and have a good morning or afternoon wherever you are.